We move on to David Teale speaking about his knowledge of the prosecution code, which then seems to be some confusion on because he's not even sure whether there is a prosecution code or whether there was one in 2008. But it appears there's been one from 2001, but then he seems to bizarrely claim that he would, of course, have this to hand. In any case, he seems to be following the things mentioned in the prosecution code anyway, but there does seem to be an inability to quite put his finger on when he became aware of such prosecution code, which was key to prosecutions in Scotland. Let's jump into the inquiry.
Can we turn to the second issue I want to ask your assistance on, please? Namely, the test that a Procurator Fiscal applies when deciding whether to commence criminal proceedings against an individual or not. Is it right that that's governed by a document called the Crown Office and Procurator Fiscal Service Prosecution Code, or the Prosecution Code for short?
I don't know if there was a prosecution code in 2008.
I think we got one that starts in 2001.
Okay.
The first edition of it. Was that a document that you would have at your fingertips?
Clearly not.
You mean physically, or just know what it's about?
Yes, either or both.
Oh, yes, of course.
We didn't know it existed a second ago.
Can we look at the one that has been provided to us? WITN 1051-0101. You can see this was first published on the 1st of May 2001, but it was updated last year in July. And it's not possible to tell which parts have been the subject of amendment between those two dates. So I'm not saying.
But I guess one of the issues is here he seems to be unaware of the prosecution code and whether it existed in 2008 when clearly it had existed for 7 years previously. But then interestingly says, well, of course I would have had it to hand. That seems to be somewhat contradictory. So anyway, if we look at the prosecution code, that would have been followed anyway. Strategic aim of it is, as a department of the Scottish Government, we aim to play a pivotal role in the achievement of the purpose of the criminal justice system of maintaining the security and confidence of the people of Scotland by providing just and effective means by which crimes may be investigated and offenders brought to justice. So that's a bold aim. Have they stuck to that here?
Saying that this was, in these precise terms, applicable when you made your decision in 2008. But I just want to get your evidence, please, on the test that Procurators Fiscal applied. If we just look, if we scroll down, please, and look at criteria for decisions. Thank you. In considering the action to be taken in relation to reports of crime, the prosecutor must take account of both legal and public interest considerations. Is that a familiar distinction to you?
Yes.
So is it right that in Scotland too that there were two elements to the test?
That's correct.
Okay. And then under the heading legal considerations, in considering cases, the Procurator Fiscal must decide whether the conduct complained of constitutes a crime known to the law of Scotland and whether there's any legal impediment to prosecution. For example, it may be necessary to consider the effect of any delay, and then something about international law, and then evidential considerations, sufficiency of evidence. The Procurator Fiscal must be satisfied that there is sufficient admissible evidence to justify commencing proceedings. In general, for there to be sufficient evidence, there must be corroboration. That is, evidence from at least two separate sources to establish the essential facts of the case, i.e., that the crime was committed and that the accused was the perpetrator.
So on that, we've got those two phrases again. They've got to satisfy that the crime has been committed and that the accused was the perpetrator. And regardless of his awareness of this prosecution code, which came out 7 years before the case in question, he said he was aware of those evidential considerations in any case, so should have applied them regardless of his awareness.
And then we see reference to the burden and standard of proof. The prosecution must prove these matters beyond reasonable doubt. And then there's a bit about the sources of evidence, and then if we move on, please. We then see that the prosecutor, under these next three headings, before we get to public interest considerations, is directed to consider admissibility, reliability, and credibility. So admissibility, laws of evidence determine whether a court can consider certain types of evidence. The prosecutor will assess whether, having regard to the laws of evidence, a court will allow the evidence to be considered in the case. And then reliability, although there may be sufficient admissible evidence to justify criminal proceedings, consideration must also be given to the reliability of that evidence. This involves an assessment of the quality of the evidence. And then credibility, as with reliability, the assessment of the credibility of evidence is ultimately a matter for the court. However, there may be doubt about the credibility or truthfulness of a witness's evidence, etc. Are those three things, admissibility, reliability, and credibility, things that when you were making decisions as a Procurator Fiscal, you consistently addressed?
Yes.
And on reliability, would you accept that if your case is founded on evidence that's produced by a computer, then it's necessary for the prosecutor to consider the reliability of the evidence produced by that computer?
Yes.
Now, the document then turns to consider public interest considerations, which I'm not going to address with you. What the prosecution code does not do is describe the test that a prosecutor must apply when deciding whether to commence criminal proceedings or not. Do you understand? It says the things you must address are evidential sufficiency and public interest, but it doesn't say what the test is that a prosecutor must apply. What was the test that the prosecutor must apply?
I don't know. I'm sorry, I just don't know what you're saying, what you're asking me.
Well, in England and Wales, a prosecutor is directed, and has been for the last 2 decades, to be satisfied that there is a realistic prospect of a conviction. And the code in England says that a realistic prospect of a conviction is an objective test, and it explains that realistic prospect of conviction means that a jury or a bench of magistrates, properly directed in accordance with the law, will be more likely than not to convict the defendant of the charge alleged. So there's an explanation of the standard that must be achieved in the prosecutor's mind.
Basically a greater than 50% chance, which, is a reasonable threshold. So I'm imagining something similar in Scotland, maybe?
In order to commence criminal proceedings.
Well, that doesn't exist in that form in Scotland.
What test was applied?
Public interest.
No, that's the public interest is addressed whether separately in the document, whether, for example, proceeding is in the interest of the victim, the accused, and the wider community, and matters of that sort. I'm asking about the evidential sufficiency part of the test. What test was applied?
There isn't a test as such, as I understand it from what you're asking me.
Well, what approach was taken then?
Well, we look at the evidence. We look at the evidence and judge: is it admissible? Is it reliable? And is it credible?
And overall, is there a compendious approach that you take when you've done those things? I think there's enough evidence to go ahead. I believe there's enough evidence to go ahead. I guess there's enough evidence to go ahead. I think it's more likely than not that the accused will be committed. I'm fairly sure that that's so. I'm certain that that's so. Was there no fulcrum around which the issue turned?
No, you're very much guided by what the report tells you.
So it seems like it's very much a lot more subjective in Scotland, at least at the time, but seems to have currently, based on that document updated in 2023, compared to a very objective test in the rest of England and Wales.
That you assess the quality of the evidence and whether there's sufficient evidence, sufficient corroborated evidence from 2 sources pointing to the facts that the crime has been committed and committed by the accused.
What I'm trying to probe is it's correct then that in Scotland there was no test that was applied across the Procurator Fiscal Service, so far as you are aware, that ensured consistency of decision making, so that everyone had a datum point past which the evidence must pass in the prosecutor's mind before proceedings were commenced?
No.
What test in your own mind did you apply? I think this case will succeed. I believe this case will succeed. I suspect this case will succeed. I'm pretty convinced this case will succeed.
No likelihood of success doesn't come into the decision whether to prosecute or not.
That was an irrelevant consideration, how likely it was that the evidence was sufficient to establish guilt.
There's some cases that you would take up that you would think, you wouldn't say, I'm bound to succeed in this case, or I'm doubtful whether I'll succeed, so I won't take it up. If they're sufficient and it's in the public interest to prosecute, then by and large, you would take that decision to prosecute.
Which I guess can amount to the same thing, because surely if you think there's sufficient evidence and you can see that as a legal expert, then presumably that would be what you would think the view of a judge or jury could be in the trial.
Very well. That can come down, thank you.